Hello everyone. Today we will be discussing some multiple choice questions on intellectual property rights, that is IPR. In this video we will be taking up some more questions on trademarks. So without wasting much time, let's start our video. Question number 1. The registration of a trademark can be refused on the basis of option A. Absolute grounds for refusal of registration. Option B. Relative grounds for refusal of registration. Option C. Both option A and option B. Or option D. None of the above. So the correct answer for this question is option C. Both option A. Absolute grounds and option B. Relative grounds. Question number 2. Which section of the Act lays down the absolute grounds for refusal of registration? Option A. Section 8. Option B. Section 9. Option C. Section 11. Or option D. Section 20. The correct answer for this question is option B. Section 9. Question number 3. Which section of the Act lays down the relative grounds for refusal of registration? Option A. Section 8. Option B. Section 9. Option C. Section 11. Or option D. Section 20. The correct answer for this question is option C. Section 11. Question number 4. Which of the following is not an absolute ground for refusal of registration? Option A. Devoid of distinctiveness. Option B. It contains scandalous or obscene matter. Option C. Similarity of goods or services. Or option D. Is of such a nature as to deceive the public or cause confusion. So the correct answer for this question is option C. Similarity of goods or services. Question number 5. The registration of a trademark cannot be refused on the ground that option A. It is devoid of distinctive character. Option B. It is likely to cause confusion to the public. Option C. It is similar to a well-known mark. Or option D. It has not been used at all by the applicant. The correct answer for this question is option D. It has not been used at all by the applicant. Question number 6. Registration of trademark can be opposed by option A. Any person. Option B. Only interested person. Option C. Government. Or option D. Trader. The correct answer for this question is option A. Any person. Question number 7. Opposition to registration of trademark can be filed within option A. 2 plus 1 months. Option B. 18 plus 1 months. Option C. 4 weeks. Or option D. 3 plus 1 months. The correct answer for this question is option D. 3 plus 1 months. Section 21 of the Trademarks Act 1999 deals with the provisions for opposition to registration. Section 21 Clause 1 states, any person may within 3 months from the date of the advertisement or re-advertisement of an application for registration or within such further period not exceeding 1 month in the aggregate may give notice in writing in the prescribed manner to the registrar for the opposition to the registration. Question number 8. What is considered to be the date of registration of trademark according to the law? Option A. The date on which registration of trademark is approved. Option B. The date on which the application for registration was made. Option C. The date on which the application for trademark is published. Or option D. None of the above. The correct answer for this question is option B. The date on which the application for registration was made. Question number 9. As per Trademarks Act 1999, the trademark is granted for option A. 10 years in total. Option B. 10 years but may be renewed from time to time. Option C. 15 years in total. Or option D. 20 years may be renewed from time to time. The correct answer for this question is option B. 10 years but may be renewed from time to time. Question number 10. The right to sue in a trademark infringement suit vests with Option A, registered proprietor. Option B, registered user. Option C, permitted user. Or option D, both option A and option B. The correct answer for this question is option D, both option A, registered proprietor, and option B, registered user. Question number 11. The use of deceptive trademark may lead to option A, passing off, option B, infringement, option C, both option A and option B, or option D, none of the above. The correct answer for this question is option C, both option A, passing off, and option B, infringement. Question number 12. A registered trademark is infringed by any advertising of that trademark if such advertising, option A, takes unfair advantage of and is contrary to honest practices in industrial or commercial matters. Option B, is detrimental to its distinctive character. Option C, is against the reputation of the trademark. Or option D, all of the above. The correct answer for this question is option D, all of the above. Question number 13. A trademark infringement suit can be filed at option A, District Court, option B, High Court, option C, Supreme Court, or option D, Intellectual Property Appellate Board. The correct answer for this question is option A, District Court. Question number 14. Section 36A of the Act, which provides provisions for international application and international registration for trademark, was added to the Act when India acceded to which convention or treaty? Option A, Paris Convention. Option B, Madrid Protocol. Option C, TRIPS Agreement. Or option D, none of the above. The correct answer for this question is option B, Madrid Protocol. Question number 15. The duration of international registration is option A, 10 years, renewable after time to time. Option B, 10 years, may be renewed for a period of 10 more years. Option C, 20 years in total. Or option D, none of the above. The correct answer for this question is option B, 10 years, may be renewed for a period of 10 more years. Question number 16. A registered trademark may be removed from the register of trademarks on the ground that option A, the trademark proposed to be used was registered without any bona fide intention to use it. Option B, there has been no bona fide use of the trademark for a continuous period of 5 years from the date of registration. Option C, there has been no use of the trademark due to the restrictions imposed by any law or regulation in India. Or option D, both option A and option B. The correct answer for this question is option D, both option A, the trademark proposed to be used was registered without any bona fide intention to use it, and option B, there has been no bona fide use of the trademark for a continuous period of 5 years from the date of registration. Question number 17. Collective mark is registered by option A, partnership firm, option B, association of persons, option C, individual, or option D, a company. The correct answer for this question is option B, association of persons. Section 21G of the Trademarks Act 1999 defines collective mark as a trademark distinguishing the goods or services of members of an association of persons not being a partnership which is proprietor of the mark from those of others. The collective mark must be capable of being represented graphically and meet other requirements as are applicable to registration of trademark in general. The examiner should look into the following factors. Number 1. The collective mark is owned by an association of persons not being a partnership. Number 2. The collective mark belongs to an association which itself does not use the mark and its use thereof is reserved for the members of the group. Number 3. The members may use the collective mark if they comply with the requirements fixed in the regulations concerning the use of the collective mark. Number 4. The primary function of a collective mark is to indicate a trade connection with the association or organization who is the proprietor of the mark. Question number 18. The function of certification mark is option A, to indicate trade origin of goods. Option B, to indicate certain characteristics or quality of goods. Option C, for government purpose. Or option D, both option A and option B. The correct answer for this question is option B, to indicate certain characteristics or quality of goods. Question number 19. Certification mark can be registered by option A, any person. Option B, any person who carries on a trade in goods of the kind certified. Option C, the person who is competent to certify the goods. Or option D, all of the above. The correct answer for this question is option C, the person who is competent to certify the goods. Section 21E of the Trademarks Act 1999 defines certification trademark as a mark capable for distinguishing the goods or services in connection with which it is used in the course of trade, which are certified by the proprietor of the mark in respect of origin, material, mode of manufacture of goods, and etc. The certification mark may only be used in accordance with the defined standards. While the collective mark may be used only by a particular enterprise, for example, members of the association which owns them, the certification mark may be used by anybody who complies with the defined standards. The entity which applies for the registration of certification mark must be competent to certify the products concerned. Examples for certification trademarks are number 1, egg mark for agricultural products, number 2, ISI mark for industrial products, number 3, BIS hallmark to certify the purity of gold jewelry. Question number 20. Trademark right can be assigned. Option A, with goodwill. Option B, without goodwill. Option C, with or without goodwill. Or option D, none of the above. The correct answer for this question is option C, with or without goodwill. That's all for today. I hope you all learned something new. In our next video, we will discuss some questions on geographical indications and plant varieties. Keep learning. All the best.